Good afternoon, everybody. I'm your host, the Supreme Litigant, and I am back again with another video. Before I begin, y'all know the routine. If you haven't already, please go ahead and subscribe to my channel and pound that like button, and I'll give you a couple seconds to do that. All right, thank you. Now let's get into the topic of this video. In this video, I want to talk about the method that these police officers do to get you basically to take you to jail. That's basically, to file so-called criminal charges against you. So let's start here. Anytime you're dealing with a criminal case, if you're in Alabama and you're dealing with a criminal case, you want to read these rules right here, the Alabama Rules of Criminal Procedure. Although these are not, none of this stuff is criminal, it's all civil. But anyway, and you want to scroll down to commencement of criminal proceedings. So we're gonna close this one, and where we at? Where's that? Boom, right here. Yeah. Damn it! I think I might have shut the page down, y'all. Give me a second. Yeah, I did. All right, let me pull it back up. So we're gonna go here. Where is it at? Bingo. All right. So scroll down, and we're gonna go to commencement of criminal proceedings. So you click that, and this will pop up right here. And this is gonna tell you. This is going to give you all of the rules. These rules were created by the Supreme Court of Alabama. So it says all criminal proceedings shall be commenced either by indictment or complaint. That's it. It's the only way that they can procreate quasi-criminal charges against you, or these so-called criminal charges against you. So we're going to close this, and we're going to go to contents of a complaint. This is going to tell you the ingredients that they need to have a valid complaint, or the elements of a valid complaint. Where is it at? The essential facts. Okay, here we go. I'm gonna read this to y'all. If you go to Alabama Rule of Criminal Procedure, Rule 2.3, it's gonna tell you this right here. All right. So we're gonna scroll down. Contents of a complaint. A complaint is a statement made upon oath before a judge, magistrate, or official authorized by law to issue warrants of arrest, setting forth essential facts. In other words, elements, ingredients. Okay? They need these elements, these factual elements. They need to allege these against you. Facts, 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 facts. It's always the facts. Anyway, setting forth essential facts constituting an offense and alleging that the defendant committed the offense. Let me scroll down because they have the authorities to support why they're saying what they're saying. You'll find that here if you go to Rule 2.4. There's going to be an authority down here. You see this right here from 1958. This is a United States Supreme Court case. Okay, I'm gonna read y'all this because this is what these idiot police officers who don't know law. They do not know law. 9 out of 10 of these people are these police officers are incompetent. They should not be law enforcement officers because they don't know what the hell they are doing. They don't know what they are doing. But anyway, the purpose of the complaint then is to enable the appropriate magistrate to determine whether the probable cause required to support a warrant exists. The magistrate must judge for himself the persuasiveness of the facts. Let me read this again. I'm gonna highlight this shit for y'all because I keep stressing to y'all. It's all about the facts. I don't care if it's a criminal case or a civil case. It's always the facts because the facts are the elements to a particular cause of action or a crime or to a defense. It's the same damn thing in a civil case or a criminal case. It doesn't matter. But anyway, the magistrate must judge for himself the persuasiveness of the facts relied on by a complaining officer to show probable cause. He should not should not accept without question the complainant's mere conclusion that the person whose arrest is sought has committed a crime. They do that all the time. And I'm going to show y'all what these idiots be doing. Where is it at? So let's say we're going to go to the Alabama Code right here. Notice I said code. These are statutes, by the way. The reason why I'm telling y'all that is because I don't care what type of court you're in if you're in Alabama, whether it be municipal, circuit, or district. If they are in there following statutory procedure and enforcing statutes, that is not a court. That is an administrative agency. That is what that is. Because the judiciary does not follow statutory procedure. Pay attention to that. And administrative agencies are members of the executive branch of government, and they exercise quasi-legislative and quasi-judicial authority. That is what they are now doing, y'all. But anyway, let's get back to this. So let me show you what these stupid police officers be doing. So, they'll say in whatever court it is, they'll put circuit, district, or municipal, whatever, name of the county or the city, which is another word for municipality. And it'll say state of Alabama, blah blah blah, municipality or whatever the city is, and then of course your name or the defendant's name will be there or whatever. But let's just focus on this right here, where the facts are supposed to be, because this section right here is extremely. This is one of the most important sections in this complaint, the facts section, because the facts will always determine if you have been lawfully arrested or unlawfully arrested, if you have been lawfully detained or unlawfully detained. They will always determine that. In other words, they'll always determine if you have been reasonably arrested or unreasonably arrested. Reasonable means lawfully. Unreasonable means unlawfully. Simple. Anyway, so this is what these idiots do. They'll come to a statute or whatever that they're alleging that they believe that you did or whatever, and they will copy and paste this. And they'll just, they'll paste it right there or whatever. And what they'll do is they will edit this. They'll edit this to put your name in it, to make it seem as if you committed the alleged offense that they are alleging that you committed. But they do this not in a factual manner. They do this in a conclusory manner. And let me show y'all let me give y'all another different. Let me show y'all the definition, the legal definition of conclusory. Conclusory, consisting of or relating to a conclusion or assertion for which no supporting evidence is offered. They do that all the time. And I'm going to tell y'all something. You cannot, I repeat, you cannot file a 42 section 1983 lawsuit in federal court or state court against a police officer in a conclusory manner. In other words, without facts supporting why you are suing that police officer. You cannot do that. When you do that, I'm going to tell you what they're going to do, and I'm 100% sure that they're going to do this 100% of the time. They are going to file a Rule 12b-6 motion to dismiss for failure to state a claim for relief. That's what they're going to do. Unless they want to milk their client, just get some money out their client. That's what they're going to do. Because that is a principle. You can't do that in a civil case, and you damn sure can't do it in a criminal case, because that's a violation of due process. How are you going to defend against substantiated allegations against you? How you going to do that? That you don't even know what you don't know what allegations you are defending yourself against. So how are you going to do that? You can't. It's a violation of due process. That's why I just read y'all that definition for facts. They talking about facts. It's always the facts. I keep telling y'all that. It's always the facts. And who knows the facts of your case better than you? So just think, if you knew the law, the relevant case law, and you knew how to apply that case law to the facts of your case, do you know how dangerous that would make you in court? I'm trying to get y'all on my level where I'm at because I know how to do that. So anyway, they'll make these allegations against you in a conclusory manner. That's what they do. Let me show y'all some few case laws on this because that's a violation of due process. Where a complaint in a quasi-criminal prosecution fails to charge an offense because they don't have facts, it will not support a judgment of conviction. And the only proper judgment is an acquittal of the defendant. That's it. I'm gonna tell y'all a story. I was in court one day, and the officer who wrote the ticket, he didn't show up. So in other words, they didn't have a witness. So in other words, they didn't have somebody to testify. So without a witness to testify, they didn't have the facts to determine my guilt. So anyway, the judge looks at me because he thinks he thinks I don't know what the hell going on. So he looks at me and he says, "Well, sir, do you have anything to say before I rule, before I make a ruling on this case?" And I say, I look at him and I smirk and I laugh a little bit, and I say, "Now, Your Honor, you know you can't do that without a competent witness." And he looks up at me and he started laughing. He said, "You're right. Now get out of my courtroom." And everybody just started laughing or whatever. These people playing games with y'all, man. That's what they be doing, man. Because he can't do that without a competent witness. He needs facts. The judge needs these facts. And what the judge will do with these facts is the judge will take, he will apply the relevant case law to the facts of the case, and she or he will determine if the facts are sufficient in law to justify a conviction against you. They do the same thing in a civil case when you're suing a police officer. They will look at the facts of the case and they're going to determine if these facts are sufficient to justify, or in other words, to sustain a cause of action for, let's say, excessive force against a police officer. That's what they're going to do. They do the same exact thing, man. These are principles, and y'all need to understand this. It's always the facts. If they don't have facts, you motion to dismiss because the complaint fails to charge an offense like this one. It fails to charge an. I'm talking about like in a criminal case. The complaint fails to charge an offense. It's vague. It's conclusory. It's devoid of the prerequisite elements of the offense, and it's legally insufficient as a matter of law. It violates due process. This is a shotgun pleading. Get this out of here. This ain't even a complaint. I don't even know why I'm here. As a matter of fact, prosecutor, are you even prepared to pledge your bond? Your bond that you have with the Division of Risk Management under the state's blanket bond. Are you prepared to pledge that as collateral if I get damaged in this case? Just ask some questions like that. Watch what they do. Just ask some questions like that. Ask them. Watch what they do. Oh boy, these folks be playing games, man. Don't let these people play these types of games with y'all, man. Always go and read the rules. Go read the rules. There are civil rules and there are criminal rules. Go read the rules and read cases. Now, if y'all want me to pull up some more cases on this, if you're not understanding it and you want me to pull up more cases on it, let me know and I'll do a couple videos. But that'll be the end of this video. Everybody enjoy your day. The Supreme Litigant is out. Peace.